All right, so let's try to start on time so that we actually have adequate time at the end for discussion. People are probably still going to trickle in from time to time. So welcome to the, I guess, last session of the conference. This is one of the several panels that's currently happening in this time slot. This is the second leg of this kind of two-step roundtable that we organized for this conference on the topic of Chinese legal history. And yesterday's main topic was legal knowledge and the construction of the legal profession. Today's topic shifts more away from that kind of structural feature to something that's more about substantive law. And so the four panelists here are going to have a conversation to which all of you guys are warmly invited to join on the kind of the content, the shape, the structure, and the nature of economic regulation and legal economic regulation by laws or other kinds of normative authorities in late imperial and perhaps Republican China. So I'm going to briefly introduce the panelists, and then we'll just go straight into the opening remarks. So we're going to start off with Professor Peng-sheng, who's a professor of history at the Shanghai Jiaotong University. Prior to that, he worked in Hong Kong for a number of, he taught in Hong Kong and Taiwan for many years, one of the most senior scholars in this field. Next up is Professor Fei-hsien Wang, who is a associate professor of history at the Indiana University, Bloomington. Specialist and expert in, at least based on the first book, intellectual property and its various kinds of social manifestations in late Qing and Republican China. So I'm up next. I'm Taisu Zhang. I'm a professor of law at the Yale Law School. And then finally there's Chen, who is a professor of history at the University of Iowa, and who the first book that she published a few years ago was about land institutions and property rights, or property rights of institutions on the kind of northeastern Chinese frontier. So it's kind of a very nice combination of regional variation, topical variation, and we hope to at least bring you guys some kind of interesting discussion today. So the format is going to be, each of us are going to make something around 10 minutes of opening remarks, followed by perhaps a 10 to 20 minute section in which we exchange some basic questions to flesh out some of the core themes of these presentations. And the final, hopefully 40 minutes to half an hour will be left for interaction and comments from the audience, to which we will respond as fully as we can. So Professor Chiu, you're up first, and you should feel free to share your screen so that you can use your PowerPoint.
Yes, thank you. Thank you, Taisu. So the topic of my presentation, good evening, everyone. The topic of my issue is about the commercial law in 18th century China. And I think I should introduce the basic background of this phenomena. So why the commercial law has some development in 18th century China. So some scholars have highlighted that there was a Smithian growth because of the long distance trade. It facilitated national division of labor from 16th century on. So it constituted by 4 major routes from Yangtze River, Grand Canal, coastal line, and the route across Mongolian steppe. So this is the basic engine to initiate this kind of so-called commercial law development. And some scholar has emphasized, concluded that there were 6 significant economic changes from 16th century on. So like the merchants becoming much wealthier, the growth of putting out system, and the evolution to a more efficient tenure system, legal reform on the status of hired laborers, large-scale inflow of silver. So, but however, most of scholars in Chinese economic historian, they will emphasize that China still lacked the necessary constitutional change for protecting the property rights, and especially it's kind of deficient in forging a body of a commercial law. So this is the basic situation we have now, the basic understanding we have now. So like the famous historian Brodeur, he emphasized that in China, the state always will put high pressure on the very rich and powerful families. So the true Chinese capitalism only existed outside China. And in this kind of circumstances, only existed the local complicity of merchants and corrupt mandarins. The Chinese state showed constant hostility to the spread of capitalism. I think it's most of the legal and economic historians in China, we still hold this kind of position. But my studies will try to balance this kind of understanding. So the topic of my presentation will try to introduce the so-called commercial law, how it developed in 18th century China. So the term of commercial law I used here is the empirical understanding of the relations between commerce and the merchants. There were three basic backgrounds in 18th century China about this kind of commercial law. The first is there existed many activities in local and central administration that could enlarge and sharpen this empirical understanding, which was promoted either by the lobbying of merchant groups or through collective merchant lawsuits in cities in the lower Yangtze and other prosperous areas. The second is dozens of favorable regulations and hundreds of rules resulted in cities and constitute a kind of castle, the so-called castle, and henceforth enhanced the degree of protection for commerce and manufacturing. The third background is many of the provincial regulations created in some provinces, which resulted in the administrative and juridical experience with commercial affairs in different cities along the long-distance trade routes. So I have two basic observations towards the so-called commercial law in 18th century China. The first one is the linkage between law in theory and the law in action. China had an existing legal code with a certain degree of flexibility. So this could accommodate many newly emerging social and economic phenomena of the time. So for this reason, legal specialists and the judicial officials in China had a little need to publicly advocate or create new concepts or theories in legal realms, nor did they need to put great effort into collecting, differentiating, and formulating the so-called customary law. So the judicial officials in every locality could still gradually have incorporated the gap between local legal norms and the larger social economic situation. The second observation my study is the ability to discuss legal cases purely in terms of law. Judicial review, the so-called judicial review, from local code to central code, has become ever more stringent in 18th century China. This produced some intended and unintended consequences and fostered various kinds of legal professionals. There include at least 3 groups of this kind of legal professionals, like official, semi-official, like the so-called private secretaries. I think some audience might have understood this kind of legal professionals through the study of Professor Chen Li. And the third group is some kind of private actors, happened in private sectors of the so-called litigation masters. So these 3 groups of legal specialists may fostered the judicial system, became more able to discuss legal cases purely in terms of law. So this is the 2 observations my study showed. Yeah, it is my presentation. Chairperson, thanks.
All right, thank you, Professor Chiu. And so do you mind stopping the screen sharing?
Yes.
Thank you.
Thanks.
Right, so Fei-hsien is up second.
Okay, so can you hear me now? Okay, cool. So first I would like to thank you all for coming to our panel and thank Taisu for organizing this panel. So Professor Chiu just talked about how commercial law in 18th century China evolve and develop and remind us the flexibility of Chinese state had in accommodating a rapidly commercialized Chinese society by acknowledging case law and issuing provincial regulations when dealing with commercial and property related disputes among merchants. And so my presentation will focus on another social legal mechanism popular among the merchants in late imperial and early 20th century China for property protection and dispute resolution, i.e. the merchants guild, merchant civil organization, Hanghui, Shanghui, Huiguan, or usually translated into English as guilds. Then I will use a case of how booksellers in Shanghai utilize such guild to define and protect a new type of property, copyright, and use it to illustrate how Chinese merchants established customary legal regime parallel to the state's formal IPR regime, and also to and talk about how the merchants and the state may have very different definition and the nature of this new kind of property. So in late imperial China, especially after 18th century, in commercial centers and market town along the major trade routes, we can see a strong presence of merchants organization, Hanghui, Gongsuo, Huiguan, most of the time translated as guilds in English. These are civic organizations formed by people either from the same region or engaging in the same trade or craft. They promote mutual assistance, promote collective interests, and most importantly, their job was to, the objective or the goal of such organizations to maintain a trade or craft community's internal order. They did so by self-regulate a regional market. They would do things such as standardize measurements, validate identity and credential of merchants, and they will also validate contract and merchandise when necessary. Another major task those guilds did was to mediate commercial and property disputes among their members or occur in the trade in their region. For Max Weber and later other Weberian scholars, such Chinese guilds were medieval establishments that prevent Chinese society from transforming into a modern and rational one, and that's like also that's also have been sometimes used by scholars as an explanation of why modern capitalism did not emerge in China in time. However, as historians of China, such as William Roy, Nagashi Tadashi, Nishida Noboru, Zhu, and also Professor Chou's research have shown these guilds as self-regulating institutes and quasi-legal authorities actually play a very important role in protecting and regulating economic conduct. They serve as an administrative intermediary with certain level of state permission. So as most of the imperial code did not address the subjects of commercial disputes, local ministries have to rely or outsource to those merchants guild to mediate disputes and to regulate the market. So one thing I would like to point it out that unlike land, the transaction, the ownership and value and quantities of commercial assets, means of production, capitals, merchandise, commodities that are very crucial for the merchants. They change very frequently, and so the ownership and their conditions are constantly very fluid. So it's very hard to register or track unless the government are willing to invest enormous administrative resources. And so that's why the imperial Chinese state would let the merchants handle this business on their own. And when the merchants or the merchants organization if they were unable to reach a resolution, then they can always report their case to the state authority and rely on formal legal, resolve the problem through local, through more formal legal channels, and that's what Professor Chiu just pointed out. And so I'm going to use my remaining time to talk about the example of Shanghai Booksellers Guild and how they utilize this pre-existing self-regulation mechanism to register and protect a seemingly new form of property. So in short, the concept of copyright as a kind of property was introduced to China at the turn of the 20th century. And the notion of copyright then at the time was known as the Western Dutch progressive and universal doctrine China needed to adopt in order to become modern. While the Chinese government was pressured from various fronts to adopt modern copyright law, Chinese booksellers and publishers in Shanghai at the time, the new center of the country's publishing industry, have actively employed this new concept to justify the ownership of their newly published book, as well as to ensure the exclusive profit those books can generate. They believed that copyright would help them to combat unauthorized reprinting, i.e. what we know as piracy nowadays. And this would also be a great tool for them to further create a sense of order in a rapidly changing book market when people have hard time differentiate one book from the other, and also to identify who was the rightful and legit publisher of a certain title. But at the time, they decided to use a pre-existing but very weak guild to register what they consider as copyright, and use that registration as the textual base for future ownership disputes. Eventually, what they found was a customary copyright regime, and they did that years before an official copyright law was ever issued in China. However, they have a very different understanding of what kind of property copyright was. So what was registered at the guild were tangible means of production. Manuscripts they purchased, the contract they signed with authors, and the printing blocks, etc. letters that can be used to produce book. And the booksellers guild's registration have no expiration date, so it's very different from our modern understanding of copyright protection. And also, as the creator of those texts were excluded from the guild's existence because the guild only mostly recognized copyright as a tangible form of property. On the other hand, Chinese government, they throughout the first half of the 20th century issued various copyright law. Like most of the modern copyright law, this various of formal copyright law, they acknowledge and protect intellectual and artistic creation as a form of property. However, there is a string attached. In order to have your copyright be recognized by the state, you have to register at first. So unregistered book and artistic creation were considered uncopyrighted by the state, and that pirating then would not be considered as a copyright, would not be considered as a property infringement. So what we see in the first half of the 20th century is a very interesting phenomena. On the one hand, you have a customary copyright regime work fairly effectively in a regional scale, but it did not have any legal basis. On the other hand, you have formal copyright law, but it was not enforced seriously by the state for various reasons. And so while the state tried to expand their effort to in issuing more formal regulation for different kinds of property, it did not work in reality. And the bookseller, to a certain extent, still enjoyed their self-regulation autonomy, but increasingly they found themselves caught in between these two regimes. And in a way, the flexibility that Professor Chiu pointed out in his presentation over time got lost when the state now have a firmer definition of what counts as a legit property and what does not count as a legit property. And I will stop my presentation here.
All right, so thank you, Fei-hsien. I'm up next, and I think our agreement was that I should kind of do some general introductory remarks on kind of the nature of Chinese landholding in I guess what we call core Chinese regions during kind of like the 18th and 19th and perhaps early 20th centuries. Now, by core Chinese region, this is kind of like a Qing specific terminology, which basically refers to like the relatively stable, high economic productivity core regions of the Qing Empire. Right? So the Qing is a much bigger empire than most of its predecessor Chinese dynasties, and that it not only had like this Han Chinese economic core, but it also had like a number of frontier regions, right? So what Chen is going to talk about in a bit is what actually happened in the northeastern frontier, and of course beyond that, the Manchus also conquered basically what is currently modern day Mongolia and Xinjiang and Tibet, and merged all of these previously somewhat disconnected sections, disconnected regions into a single empire. Now, of course, the rules and institutions governing economic interactions differed pretty significantly between various regions. So so we decided to kind of like split things up. I'm going to talk about mainly kind of like the Chinese core, which is for the most part the highest productivity, wealthiest, most populous, and also like most commercialized, most urbanized part of the empire. And Chen is going to focus on the frontiers, where to some extent there was actually more political action going on, but the rules were different. So there's a very long literature on basically what Chinese land institutions actually look like in this section for a very long time, when people were considering this kind of like eternal question. And this has always been one of the eternal questions in global history, what made China fall behind? economically mainly, and fell behind specifically the West in the 18th to 19th centuries. Like for many, many years, people were obsessed, and to some extent still are kind of obsessed, with using land institutions to explain the divergence. So over many past decades, the primary interest for many of us, and I will profess to being somewhat guilty of this, was to find like what was the economic problem with Chinese economic institutions. And this is not obvious. This is obviously not the kind of like neutral perspective that historians are supposed to take. But if you're a comparativist, or I guess like a global legal historian instead, then you can't help sometimes but come into these kinds of questions with certain kinds of comparative agendas, and that inevitably demands a certain kind of theorizing, and it demands a certain kind of oversimplification. It also demands a certain kind of like a priori framing that we simply can't escape. Nonetheless, like to its credit, the field has rejected some of the more serious and more egregious oversimplifications that it had made of Chinese land institutions during the earlier phases of this literature. So it used to be thought that for the most part, there were no such things as stable and enforceable contracts in the Qing, or perhaps even prior to 1949. People used to think that there were no such things as secure property rights in the Chinese context, whether for commerce or whether for land, right? The assumption was the state was constantly capable of taking away your land or seizing your assets. And that lack of security was a major hindrance to Chinese economic development. So you can clearly see the influence of people like Doug North and older generations of institutional economists in this kind of perspective. More recently, the field has come finally to the realization, I think this is nearly universal, and no one, I don't think there's anyone seriously working in the field who would actually argue otherwise by this point. Everyone kind of agrees that, okay, that's all wrong. If you look at the institutions of land holding, land transfer, and so on and so forth, it wasn't functionally that different from what you see, frankly, in modern economies, from a functional point of view, and from both a functional and institutional and formalist point of view. It's not all that different from what you see in Western Europe at around the same time. So one, of course, core organizational feature of this kind of like Chinese land law is basically that the law is largely, when we say law, in terms of functionality, we tend to mean things like customary law, local communal customs, and so on and so forth. There was a centralized property law issued by the Qing states that protected private property rights, protected the right to contract, and issued all kinds of specific rules for land use, land holding, and land selling. Much recent literature has demonstrated that, honestly, even for local courts, formal official local courts, their enforcement of these top-down issued formal laws was spotty at best, and in many large swaths of the law, just kind of non-existent. Instead, the functionally active and kind of most functionally powerful rules that govern things on the ground tended to be things like customary customs, made either by local villages as a collective, or perhaps by local lineages, many of whom were basically the village. Right? Like a really large lineage could pretty much occupy 65 to 75% of like a village's population. Now, that said, the interaction between central law and customary law was not necessarily one of just complete hostility or disconnect. Despite the fact that like each region tended to have its own customs, there's remarkable uniformity across the Chinese core in terms of like the basic structures and the basic institutions that you have going into land holding and land transactions. The terminology is, with some variation, relatively consistent. You can kind of like figure out what a contract says, varying from region to region, and it all tend to fit under kind of like a similar functional framework. And the basic kind of like shape and functionality of landholding didn't differ too dramatically across the empire, which in some ways like speaks to at least kind of like the intellectual prestige of the formal official law even if it didn't necessarily have that much like enforceable legal teeth on the ground, the existence of a universally acknowledged and widely read top-down issued formal law at least allowed kind of like had this kind of like focal point value in the way that local communities thought of and organized their own legal customs. Nonetheless, there are some common features pretty much across the entire Chinese core in terms of functionality that go even beyond this kind of like conceptual commonality. First is, property was secure for the most part across the Chinese core. It was privately held by households. It was basically secure. There were large swaths of property, especially in South China, that were held by lineages as common property. But those kinds of things also have many European analogies, and various kinds of communal properties and manor properties and commons that even in say like England existed all the way up to like the 19th century. That said, most land in China was privately held by individual households, and it was secure both against state expropriation and also against trespass and violation and so on and so forth by other households. So it was secure in both kind of like a vertical sense and a horizontal sense. So from that basic point of view, right, like there isn't a whole lot that's terribly strange in this early modern context of Chinese land law. If you look across the road in like the early 1800s, most land law, even in the Western world, was governed more by communal customs and local customs, and things like township laws or borough laws that had huge variation than by central royal law. There was a lot of bottom-up self-governance in these kinds of things, and in terms of functionality, that didn't prevent land law pretty much anywhere across these major economies from being relatively privatized and, for the most part, pretty darn secure. One of the good features of having these fairly weak, administratively weak early modern states is that they actually can't do all that much to expropriate your property. So your property was pretty secure. Now, what tended to vary from region to region were not these, I guess, what we would call core institutional features of property law, right? The basic shape and form of ownership was not terribly different. The basic sources of authority and rules was not terribly different. What was different was kind of like the more minute details, the more kind of finer institutional mechanisms through which, for the most part, you subdivided, leased, or sold land. And so on this front, the core characteristic of Chinese law, which is quite different from what you see in England and what you see in France or Germany or so on and so forth, was, I guess, in some relatively simplified language, it was much more egalitarian in that it gave stronger protections to the interests of smallholders. So the example, so I wrote an entire book on this stuff, and I'm not going to put you guys through the suffering of actually listening to me talk about the book. But like on a very general level, so if you're a smallholder in these times, you usually have an interest in having mortgage law be relatively lenient, not having mortgages be strictly foreclosed against you upon default. You have an interest, for the most part, in having relatively lenient terms of tenancy. In not granting landlords like an absolute arbitrary right of eviction, not letting them have an arbitrary right to fix rents, and so on and so forth. And to a very large extent, these kinds of concerns were all somewhat honored to fairly large extents in the Chinese land law from all the way back to the early Qing dynasty into the pretty much like 1920s and 30s. And even into the 1940s, you still see this kind of like relatively egalitarian land institution where the interests of smallholders in protecting their relatively vulnerable land holdings and also protecting their interests in many cases as tenants of larger landlords. Those interests were given much greater protection in the Chinese context than they were in the English context or in the Western European context, where English law, especially after 1650, was extremely harsh. Towards smallholders, there's a massive literature on this going all the way back to things like the Brenner debate and so on and so forth. And it's very long line of follow-up articles by various people, which basically show that, like English law was pretty darn harsh against tenants, against smallholders. There was kind of like this accumulating tendency of English law that tended to favor the agglomeration interests of large landowners at severe cost to smallholders. In contrast, the interest of smallholders to prevent larger landowners from easily taking over their land was largely honored and protected in the Chinese legal context. And this had quite major impacts on the distribution of land in, say, Western Europe or China, right? So if you if you look for pretty much like the century to 50 years before industrialization, in England by 1700, pretty much like the top 8% of landowners, like the gentry plus the aristocrats, owned something like 85% or 90%, depending on the estimate of all land in the country. In France, it was arguably even worse, and in the Germanic kingdoms, it was pretty much the same thing. In China, on the other hand, all the way through 1949, peasants owned, smallholders owned a substantial share of the property. This is not to say that there was no wealth inequality in China. There was quite a bit of it, but it was much less severe. Right, the top 10% of the rural population owned, instead of 85% of the land, it owned 45% of the land. And you may think, okay, that's still pretty severe in terms of inequality, and of course you're right. But in terms of general macroeconomic outcomes and the kind of socioeconomic dynamics that it produces on the ground, the top 10% owning 45% is a massively different society and economy than one in which the top 10% owns 85%. Now, I'll say a final word on why this actually emerged. So my theory, which is contestable, and we can talk about it if you guys want, is it had something to do with the way that society was organized and power was distributed in these societies. For the most part, especially in the English countryside, power and status tracked wealth. So the wealthier you were, the more likely you were to have formal titles. You could be JPs and MPs, or be somebody of recognized authority within your community. In the Chinese context, yes, some chunks of societal power track wealth as well, but at least nominally and to some extent functionally as well, a substantial share of societal status and power was allocated not on the basis of wealth, but on the basis of age. Right? This is like the Confucian social hierarchy at work. You're supposed to honor your elders, and you honor your elders regardless of how wealthy they are, right? So in this context, because some status is allocated on the basis of age rather than wealth, and age in this early modern age does not really correlate terribly strongly to wealth, there exists in most Chinese villages a substantial number of what you might call relatively poor but senior people who have some status, and they can use that status to kind of protect their own economic rights, and those rights therefore are rights and legal institutions that smallholders want instead of large landowners. So that kind of you might call this political representation amongst the kind of policymaking class of a village or a lineage or so on and so forth of these smallholders was, in my arguments, what ultimately led to this somewhat more egalitarian composition of Chinese land rights vis-a-vis their Western European counterparts. And I'm going to stop there. So Chen-Shuang, you're up. And you said you have a PowerPoint as well.
Yeah, okay, I will share my PowerPoint. Okay, so good evening, everyone, or good morning, depending on where you are. Also thank Taisu for organizing the panel, and also for introducing the theoretical background and the framework about the topic of land rights. So Taisu pretty much introduced the basic characteristics of land rights in China, how that was arranged and how that was distributed. So I would say my presentation on, here we are. So My presentation on the land rights on the frontier mainly served as kind of a case study or more substantiated discussion about how the land rights was established in the initial stage. Yeah, when usually we cannot really observe in the core areas of China. And then how the protection of land rights was achieved by both the state law and the customary laws. So basically, the areas I study mainly is Northeast China or Manchuria, but also there are quite a lot of similarities in other northern frontiers like Inner Mongolia and even like Northwestern China. And so basically, the situation I'm discussing is that there's quite a lot of state intervention in the settlement stage in those frontiers. And also the state paid a lot of attention to regulate and establish a lot of local regulations to define who can have rights, who can have the land rights and who cannot. So there's tremendous state influence in the land distribution and also property rights in those areas. So basically, there are two patterns of settlement and land clearing during which the land rights was established. So the first, of course, was settlement by voluntary and free migrants. So this included both the official, those migrants who were officially registered, and also include those who moved there on their own without being registered by the state. And so another part is another pattern was the government organized settlement or initiated settlement. Well, I would say in terms of frontier settlement, like elsewhere in the world, the government always played a very significant role in opening new land and also recruiting more people to settle there, even include the voluntary migration, like the first pattern. So without the state initiation, usually the voluntary settlement was very small scale. Only after the state opened land and recruited people, so those voluntary immigrants influx into the area. So basically the state really played a very significant role in frontier settlement. And also in terms of state organized settlement, there are two forms. So one was the organized land clearing, in Chinese is called Tuntian. So that was very institutionalized, and usually the state organized the migration and settled the people, and institutionalized the immigrants in some certain way, like in Northeast China. The 8 Banners was a major organization to do Tuntian. And also on the other side, there's another form of state-initiated settlement that was the recruiting migrants to claim land. So basically the state just decide, this part of land, this area of land is open to free claimation. So anyone can come up to claim part of land paying initial money to get the certificate from the state, and also to to start a farm, clear the land. So sometimes there were individual farmers, they did so, but a lot of times in Inner Mongolia and Northeast China, so there was some agents or tax farmers, or in Chinese it's called landtou. So they will claim a massive amount of land from the state, guaranteeing their claimation by paying a lot of money, or probably the prospect of collecting enough rent or tax. So, and then they in turn, after acquiring the certificate of the land, they will recruit immigrants into the area to farm. And so we can see that indeed there were a lot of variations in terms of the settlement form of settlement. Therefore, so the state also actively registered the land and the people, and to create a lot of proofs of ownership, the land ownership. So also I have to clarify that by using the term ownership here, I'm talking about the land the state granted considerable use rights or for ownership to people, but a lot of times, especially in Manchuria, due to the institutional setting, so the state actually claimed the ultimate ownership of the land. So, but here I just use the term ownership loosely to representing the rights, the land rights owned by the cultivators or the farmers. And so basically the government produced land registers, land certificates, and title deeds. At the same time, outside of the government purview, there were customary laws backed up by various contracts. So to back up a lot of institutions that actually the state law did not really cover. And for the state land registration, it also created some inequality there in terms of who can have land. So it's kind of a land entitlement. So only those registered residents or residents recognized by the state can officially obtain the government issued proof. So can register their land on the state register, acquire a land certificate or title deeds. But at the same time, the customary laws, the contracts actually worked with the state laws. So basically to protect the rights of the other forms of land tenure, for example, the conditional sale, the practice, and also the tenancy. So especially for the people who actually was not registered on the state register and was not entitled to own land. So the contracts really helped to back up their claim of the property and especially land. And so here I especially want to talk about one phenomenon happened in the northeast frontier and also including northern frontier. So because it first occurred in northwest China. So it's a phenomenon called the rendong, or finding a landlord. So the process of the rendong tenants' rights was protected by both the state law and the customary laws. Really proved that probably the point Taisu just raised, that actually the property rights was quite secured in some way once it was defined. And also in terms of how to define one person really own the land and have the rights. So it's not just the state law, because a lot of those people, those rendong tenants, they are not eligible to register their land under state law. And according to state law, they could not really own the land. They don't have the rights. But actually the customary law recognized the rights based on the rule of first possession. So basically the rendong tenants means the immigrants who cleared land on their own, but was not entitled to officially register the land because of the various specific institutions established by the government in that area. For example, in Northeast China, so only those registered civilian commoners and the bannermen can register their land under the government. And so what happened to those tenants? They moved there and actually had the ability to clear land. So they had to register their land under some official resident in that area and also turn themselves into the tenants of the landlords. So this phenomenon was quite prominent in that area. And so what happened was actually gradually the state law also recognized the tenants' rights, ownership of their land. So just by recognizing the fact that they occupied the land first and invested labor and capital to clear the land. So basically the rule of first possession. And so therefore, the state regulation actually worked together with the customary practices and the laws to protect the rights of the rendong tenants. And so this kind of phenomenon was first discussed by the Board of Revenue in 1744. So that was during the process of the rustication in Gansu province. And later on, it was included into the Hubu Zeli, so the regulations published by the Board of Revenue following the discussion. And what happened was those tenants' rights was secured even after the fall of the Qing dynasty. So especially beginning in 1907, when the 3 northeastern provinces was established in Manchuria to replace the previous banner system. And so a lot of reforms happened in that area, including the legal reform, that's part of the New Qing reform, and also that in that area, all the land was being transferred to private owners, even though all those owners already obtained quite a lot of rights over the land, but the state before 1907 claimed that the ultimate ownership of the land, but beginning in 1907, they officially started to adopt the idea, the concept of exclusive free property rights over land for people, and then transfer those rights to the cultivators or owners of those lands. And therefore in 1907, most of the Rendong tenants obtained their official ownership of the land they cleared in the beginning of the 19th century. So yeah, but maybe this is just a case to really reveal how actually the land rights was secured in a way that through the interaction between the state law and the customary laws, and the state would actually actively recognize those commonly agreed rules to protect the rights. And also, since Taisu discussed the implication of the land distribution in China, so based on my study of Northeast China, I agree with Taisu that the distribution of land was quite egalitarian. And so, but at the same time, in terms of the mechanism, so unlike the core area, which was mainly basically maintained by the economic life was run by feminists, but in Northeast China, we saw a considerable state intervention, and we clearly saw a state role in maintaining an egalitarian distribution of land. Even though we have to recognize at the same time that the state regulation did create inequality by excluding a lot of people from owning land, like the Rendong tenants. So yeah, initially if we look at the distribution by the state regulation and also the registered land ownership on the state registers, we can see, yeah, it's quite, on one hand, it's a very egalitarian among the people who are entitled to own land in that area, but at the same time, we can see a lot of people are not able to own land. But at the same time, if we consider this kind of customary practices and also later on was recognized and also protected by state laws, we can see that actually the distribution land was even more egalitarian than what the state land registration shows. So the records of land registration shows. So I think I will stop here just to, yeah, probably for a broader discussion later. So that's the practice.
All right, thank you, Chen. So I think at this phase, so we had planned that we would have 10 minutes for kind of like a brief discussion of methods and some common themes between the panelists, and also given that this is actually like a 2-part roundtable, we had like a set of panelists go yesterday, and most of them are here today as well. And if any of you guys want to jump in at this point and raise some general questions, we can spend like 5 to 10 minutes talking about those, and then we'll open up to the general audience. Let me start by just posing a general question, given that this is, the American Society of Comparative Law. How should we think about the use of comparative methods in this kind of a Chinese economic regulation context, right? So in some ways, like nearly all of our projects, all 4 of us are operating under some shadow of various kinds of comparative frameworks. In Professor Chiu's context, the perception of the Chinese state as being hostile to mercantile interests was for a very long time stated in opposition to kind of like a more mercantile and more pro-commerce, supposedly more pro-commerce Western states. And that, and but of course the refutation of that kind of like misperception also therefore innately has to operate with some kinds of comparative elements in mind. And we kind of can't help but make these comparisons. In Fei-hsien's case, like intellectual property is a concept that's innately shaped by pretty much Western notions of publishing and intellectual property and writing and authorship and so on and so forth. And so a large chunk of the field is devoted to kind of trying to recover what it means in the Chinese context to publish and enjoy rights of publication and so on and so forth. But to some weird Schmittian sense, that literature too is defined against the other of like what's, and that other could either be the Western notions of intellectual property or Western perceptions of what intellectual property in China should be. And in Shuang's case, perhaps like at least like the Sino-Western comparison is a little bit less oppressive. But nonetheless, as you mentioned throughout the presentation, there's a kind of contrast that everyone has to draw with about frontier regions, between frontier regions and core regions. To some extent, like what goes on in frontier regions is always spoken of in contrast to what goes on in core regions, and that's the comparative framework that you have to talk about, like state power in one region vis-a-vis the other, and institutions in one region vis-a-vis the other, and so on and so forth. So in some ways, like nearly every single major project of illustration of Chinese economic regulation in the past, I would venture 40 to 50 years, and for probably much longer than that, has been made in some kind of comparative context. Like we don't really do a good job of speaking of things purely in their own historical context. And yet, I guess the question for everyone would be, is this a good thing or a bad thing? Like I personally think it's inevitable, and that you can't conceptualize and you can't speak of anything in a somewhat theoretically rigorous way without some kind of simplification and conceptual contrast. But I know others will differ sharply with me on this point, and I just want to pose the general question. If anyone wants to jump in at this point, just please jump in. No one?
Well, I was kind of waiting for the panelists to talk. I didn't want to take up their time, but if no one wants to talk about it, I'm a comparatist, so I'm in favor of comparison. I think I kind of agree with what you said. I think it's inevitable. You always want to figure out how the phenomenon you're looking at compares to other phenomenon you know about, and with economic regulation, that would seem to be very, very useful. I wouldn't say you always have to do it, but it seems very useful to me.
Yeah, so along the line, I would say that, like, I personally, like, is also in favor of this kind of comparative research method, but not in my own case, I did not do it in a very systematic way. But just like as Taisu pointed out, like intellectual property right, like copyright is inevitably like it's embedded in my Western European experiences. But like on the one hand, like it's good to have other like cases, so to help. This in my case to put my Chinese cases in perspectives. But the danger of that, I think, like probably for most of the people who work on like non-Western, non-European legal history, or there is a potential danger of normal taking the Western or the European or the American experience as the norm, and sort of try to explain, like, or try to interpret the non-European and non-Western cases as some sort of alternative or some sort of variation. And one of the I would say methodological challenges that I have faced, and I haven't found a good way to overcome it, is because the terminology that we use are deeply embedded in and created in this kind of Western or European or American legal tradition. And so when you, especially when we write in English, and you have to use like guild, like Chinese trade and merchant organization are different from European early modern medieval guilds. But because now we use guild as a translation to refer those Chinese institutions, and well, it helps us to open up the possibility for comparison, but at the same time, we also are running into the danger of sort of like pretending that apple and orange are like the same kind of fruit. And so I have no good solution for that. I'm looking forward to hear what other people think.
So,
Yeah.
so actually, Chen, did you want to speak? Because
I wanted to defer to Professor Chiu and others with this panel, but certainly I think it's if anyone has any problem with the comparative legal history studies, I think it's not necessarily the comparison itself, but rather how are we going to do the comparison, and also to what extent there have been, I guess, I don't want to say a priori assumption, but certainly there are a lot of normative assumptions that have to be challenged or questioned in the first place before we do a comparison. But I think no one actually categorically denies the utility of doing comparative studies, because otherwise we cannot even have conversation in the first place. It's just to what extent certain comparisons can be done better or in a different way, and certain kinds of conclusions have to be questioned before we even start, I guess, the comparative work. There's a lot of comparative studies, as far as I can tell. The conclusions of those studies have already, at least to a great extent, have already been determined because of the choices that the authors have made about the questions they want to pursue, the kinds of, I guess, normative assumptions they want to either verify or confirm, and also to what extent those assumptions have to be questioned or interpreted differently, especially when we are moving out of, for example, Euro-American context or out of the Chinese context, to bring other kinds of material, other kinds of historical experiences into the larger picture. I think that's the question that has been at least subject to more or greater scrutiny over the last few decades. I know, colleagues in the field might not necessarily agree with what I have been doing in my own research, but I think this is the kind of venue where we can have more fruitful conversation across our own disciplinary or country-specific, or even sometimes, I guess, continent-specific research work. That's why I very much appreciate Professor Zhang Ritz and other scholars who are actually attending these kinds of, comparative talks. At least there is a hope of having more conversations like this, instead of we only focus on our own, whatever we call it, intellectual territory, focus on what we are interested in and what we want to write about. I think this is always, I think Taisu and many of us actually in the audience have done this kind of cultural, cross-continental conversations over the last, at least as far as I know, a few decades. I mean, it's still a small step, but there's hope that more people will be interested in this kind of conversation. So I will stop here.
Yes, I had my hand up to ask a question. I don't know if you can you hear me, what I'm saying?
yes.
Can you hear what I'm saying?
Yeah.
I'm going to greatly oversimplify this. And if you think that it's a gross oversimplification, not worth answering, you just tell me, But it seems to me that what I hear you describing about the society of China, it sounds very much like the ancien regime before the French Revolution. that a small group of people would control most of the wealth. And the French Revolution, after many zigs and zags and so on and so forth, particularly with Napoleon and his code, put forward the idea that was eventually adopted in Europe, that an individual should be evaluated by his talent, not by anything else, not by his connections or his ancestors or anything. And it seems to me that the answer, and not answer, but why China didn't develop like the West did, capitalism, is based on that. I mean, on Napoleon's idea that eventually the West adopted and got rid of the ancien regime, that each individual is equal and should rise as high as he can according to his talent. And I wonder why that particular idea never took hold in China.
Okay, so I think let me take the first stab at actually responding to that. I think the premise of the question is wrong. So in some ways, like China, as we were discussing, right, as both me and Chen were noting, right, the land distribution in China was unequal, but it was far less unequal than what you saw in the French ancien regime, right? And as for the selection of people by merit, well, the interesting thing is that the Chinese got rid of the aristocracy, or kind of like inherited political status, at a far earlier time than Western European countries did. And to a very large extent, the English civil service exams were based on the Chinese civil service exams, or like after something like 960 AD. The primary route, the most prestigious route of entry into the Chinese bureaucracy, is by examination, based on your essay skills, your political policy writing, and so on and so forth. Right, so, and that swiftly begins to dismantle during the Song Dynasty the power of these major aristocratic families that used to control pretty much all the upper echelons of the state. And so by the Qing, like by 1644, it was not exactly equal, right? Like only 10 to 20% of the population actually had reasonable access to any kind of education that could actually allow you to be competitive in these examinations. But again, 10 to 20% of the Chinese population is a larger population than the entire population of France. And within that 10 to 20% of the Chinese population, entry into the state was to a very large extent meritocratic. So whatever you pin the problem with Chinese economic developments on, it likely can't be the anti-meritocratic nature of Chinese politics.
Well, that doesn't comport with the society that you described, and that some of the other people described.
No, the society we're describing is the one in which the state is extraordinarily weak. And there is some inequality, but again, the inequality is not severe, right? Like there's less inequality in China back then than there is right now in China. There was less inequality wealth-wise in China back then than there was at any time in English history or French history, across any of the 18th, 19th, or 20th centuries. There was less inequality in China then than there is right now in the US, far less inequality, right? So there is inequality, but comparatively, the interesting thing about China is how equal it was, not how unequal it was.
Okay, it doesn't seem consistent with the society that you described during those centuries earlier.
It's a fragmented society, right? It's a decentralized society in which the state doesn't hold a ton of power, but that doesn't mean the state itself is not meritocratic, right?
Okay, well, I told you that it was too oversimplified to tell me, and I'll accept that.
All right, thank you. I think at this point, it's probably like that's our cue that we should start letting the audience into this conversation. So I'll take the cue. If anyone wants to ask a question or make a comment, please raise your hands. You also feel free to like type your questions in, but like raising hands is probably the more direct fashion. John, please go ahead.
Did you call on me? I wasn't quite sure.
Yeah, yes, please.
Okay, thank you. Well, so I wanted to follow up on that because as you know, I asked you in the private chat whether you could talk about the class structure. You were talking about why is it that China didn't develop the massive concentration of land holdings that happened in the West in the 18th century. And it struck, I just, based on my relatively fragmentary knowledge about Chinese history, I thought, well, I didn't think you had much of a nobility class.
Yeah, exactly. Right. So it's a very good question.
Surely there were gaps in wealth, but apparently not the massive gaps in wealth that I think that you found in the West, where and those massive, the really dominant landholders just gobbled up all the land.
Yeah, exactly. So that's a good point. In some ways, like people have made this argument. Especially many Japanese scholars have favored this argument. And one of the major things about China's relative egalitarianism was the lack of an aristocracy in pretty much the entire second millennium. In some ways, that solves part of the question, but it doesn't solve the entire comparative problems. Because, if you believe, for example, in like Bob Allen's account, and some of like these other English historians' accounts, then the main engine that was driving inequality in England was not so much the aristocrats, but rather like the greater gentry and the larger non-aristocratic landlords buying up land from smallholders and from yeomen, right? So it was mainly through transaction, not through inheritance, not through kind of like exclusion and destruction of the commons. Through which English landholding became so unequal over like the 16th and 17th centuries. So if you buy that account, which I guess I partially do, then there has to be kind of a question of like, was there a corresponding process in China that didn't involve directly the aristocracy so much, but was mainly about kind of like commoner on commoner land agglomeration? And that begins to beg the question of, what are the mechanisms through which you buy land and mortgage land, lease, evict tenants, and so on and so forth, right? So hence it becomes kind of more of a flat private law question than this hierarchical aristocratic constitutional question in some ways.
Could I just ask one follow-on question? And it's really for Professor Chen, because she mentioned that the state played a role in maintaining the egalitarian distribution in the area she studied, and I wondered if she could elaborate on that a little bit. That might give me some view of the mechanism you're talking about.
Yeah, sure. So in the areas I study, so there were a lot of farms established by the state following the organized migration. And for those farms, the land, the state just distributed them to the people they considered eligible to own land. So specifically for my case, they were better men. So they just followed the 20th practice. So basically they split the land into plots of equal size. So and allocated each household one plot. And throughout the time, the period that I study lasted for like 100 years. And so throughout the time, they paid much attention to ensure each household only had one plot of land. They cannot have more. So if they want to have more, they have to split the household, like have some male heirs to inherit other plots. So yeah, but they especially paid attention to maintain equal distribution of land. So I think that, played a major role in preventing the land from concentrating in Northeast China. But at the same time, also just an extension of this issue. So I would say, following up on previous discussion on the comparative perspective, I would say actually, in terms of comparison, the situation I see in Northeast China is more comparable to like France or Europe, just because they had a lot of nobility there, and because of the banner system, there were manors owned by the mainly by the imperial lineage and other nobilities. So, but and also in the wake of the fall of the Qing dynasty, there did have some large landlords arriving from that area. But the situation, the interesting part is still in terms of the real ownership, or how, or what we call how those land was operated or managed by people. So it's still small family, or probably it was not really concentrated and also used in the sense of like concentrated capital. So it's still very scattered. The ownership, the de facto ownership was quite scattered. I think that's also I'm still looking at it and see why, despite of the large landlords arriving in the early 20th century, but still the land was, I mean, the economy of Manchuria did not really go along the way as like Europe or other parts. So that's my comment or thought.
Thank you. So next we have Zhang and then Don.
Okay, thank you very much for this very exciting panel. And I certainly, because my own research focus on both forest property right and the trade of commercial disputes in the timber trade, so I feel quite well connected with the panelists. I personally fully agree with the general picture that arises from the panelists' presentation, namely that there was pretty secure property right in China, comparatively and relatively speaking, especially friendly to smaller holders, and there was a well-functioning system to deal with commercial disputes in the formal and informal legal framework. So I think I want to try to go back to some of the larger questions that have come up in the discussion already, namely with these very strong revisions to that traditional truism that use the lack of property right or the lack of a commercial law legal system to explain the slow takeoff of industrial capitalism in China. So this traditional literature has been attacked for more than a generation by scholars, first with sort of small moderation by saying that the Chinese system is sort of more or less similar to what's going on in the West or in other world regions. But more recently, I think with this round of new findings, I could even comfortably argue that the distribution of property and wealth in China is more egalitarian than what's going on in Europe in the similar period, and more compared to other world regions, even more so. So moving forward, and especially in light of the so-called new history of capitalism, how do we connect these, if we can agree on this basic description of the Chinese society prior to the industrial age, how do we connect these new general description to the result that it took longer for China to take off in terms of industrial capitalism? Would the argument be that the secured property of smallholders was a detriment to the full proletarianization of labor force, and hence make it more difficult for a new capital class to organize the large factory labor who we need to remember that in the early age of industrialization, who worked and labored in extremely harsh conditions. Certainly this is the message from, for example, Seven Becker's Empire of Cotton, where, you know, the sort of dispossession of the British labor, peasant labor in the countryside, the dispossession of their landholding and secure tenants' right, according to Becker, contribute to the availability of a large sort of labor force in the cities who are ready to be exploited in the factory setting. So in that new literature of history of capitalism, we have an abundance of these types of account. So I wonder from the panelists on thinking, how would you possibly connect your new understanding of what's going on in late imperial China to that later episode?
Professor Chiu, do you want to take the first stab at answering this question, because you're the expert, especially on capitalism?
I guess I would then first ask Chen, Shuang, and Taisu, because the two of you talk about land property.
Okay.
Sure, well, we can go afterwards, but
whoever would like to.
Professor Chiu was the expert on like the development of capitalism.
Yeah, I think to me, there in comparative level, I think after 16th century, China did emerge kind of atmosphere towards merchant. So the attitudes and the policy grew more favorable towards merchants. However, it's under a certain kind of aim. So specifically, many officials thought that to protect the merchants' property could bring benefits to peasants. So it's kind of this kind of atmosphere that connect peasants and the merchants together. So, but if you compare to the situation after the end of the 19th century, when the late Qing government, what they have done is kind of like raising this kind of protection to connect merchants' ability to national interest. They want to increase national interest by the cooperation of the Chinese merchants. So if you compare these two different atmospheres, in general we could say that Chinese merchants' status or their property right could be protected to a large extent after 16th century. However, if you compare to the situation in late Qing, it's two different kind of situation. And I think to the question, another comment I want to say is to maybe Professor Rees, because I think compared to the situation in Western Europe, to me, I'm always wondering that, like the example of Lord Mansfield in 18th century England, why China didn't occur the kind of like a general theory, how to protect like the contract or the insolvency or like a partnership. Why China did not develop a kind of a general theory about this kind of commercial affairs? So to me, after in 18th century China, the officials only protect merchants' property or or resolve the commercial disputes by some practical operation. So they just to resolve the specific problem, but not try to develop a kind of a general theory. They could like to protect the merchants by the extant framework provided by Qing Code. So I think it's a kind of, to me, like a puzzle. I'm still try to delve into. Yeah, thank you.
Great. So Chen Shuang, do you want to take the next stab, and and Fei-hsien, if you want to speak as well, please jump in.
Okay, thank you, Zhang, for the question. So actually, a lot of times when discussing why, so in terms of development of capitalism in China and also the connection with the distribution of land, sometimes we will face a criticism of agricultural fundamentalism. So, because so basically, based on the history of capitalism in Western Europe. So rural society, our agricultural agrarian society was not the place that actually capitalism really developed. So when we talk about this, I think, basically, probably there should be a lot of stepping stones to connect the concentration of land and also the development of capitalism, mainly basically the labor. So produce the proletarian class probably, So basically there were displaced laborers from the land in Europe. But so we didn't really see that in China, I would say. And also people are still attached to land. And I would say probably because I'm studying Northeast China, we can see there's huge migration in the early 20th century. So the surplus labor, a lot of them actually rushed to the new land in Manchuria and other parts like Inner Mongolia. So I would say that's something I'm observing and I'm trying to figure out still,
Great, thank you. So I'll try to leave as much time for Don to ask his question as possible. So I'll just give like a one-sentence response, which is like, I personally think that in the absence of strong modern states, which certainly there was none in the same context, inequality is good for the development of industrialization and capitalism, right? Like the problem with China was not that it was sufficient, it was too unequal, but rather that it was much too equal. You actually need large concentrations of capital to get this thing off the ground, and China never had that. But that's a controversial stance, which I will defend later on. Don.
Thank you. And thanks to all the panelists for some really interesting and stimulating presentations. So my question here is for Fei-hsien, just about this idea of an informal or a customary copyright regime. And I'm trying to understand how such a regime would actually work effectively. What would it mean to say that there's a kind of an informal copyright regime in the absence of formal law? How was this property protected? So in other words, just because booksellers agree on something isn't necessarily going to work, because in a sense, you need to have some kind of institution with a universal jurisdiction to punish the pirates. Or are you instead maybe arguing that, the booksellers in one particular place, they could agree on kind of an informal copyright system, and that, if you didn't respect that, then you just couldn't find a good outlet in that city to sell your pirated books, and so it worked in that way. So I'm just trying to understand how a kind of informal system without any state sanction would actually operate.
Okay, so like, first of all, what they register, it's not something that we would nowadays consider as copyright. And so they are registering very tangible thing, means of production. And they also, but the reason, and they did rely on institutional tradition and consensus. So the
what I'm trying to understand is, what exactly is the institution you're talking about, Don? I mean, it's fine if it's not copyright, but then what is it? I mean, was something being protected?
Something being protected, and they call it copyright. But like for contemporary, like for modern legal scholars, they will say, no, this is not copyright. But for them, that's copyright. And what they, so for example, if you publish a book, then you can register with the guild and declare that you own the copyright of that book. And then that would be, that registration entry, once recognized by the guild, then would be acknowledged by all the members. And so if then someone violate, or like someone produces an unauthorized reprint of your registered title, then you can report to the guild.
But what can the guild do?
The guild can then summon the other party, and then they will try to mediate.
But what if the other party doesn't want to show up? I mean, what if the other party is not in the guild, a total stranger? What power does this is what I'm trying to understand?
Okay.
Where's the coercion against the
okay.
who doesn't want to cooperate?
Okay, so but because at the time, like there are like for self-interest, for the reason of self-interest, because at the time basically everyone pirate everyone else.
Mm-hmm.
So you would be victim one day, but you would like everyone may be the victim one day, and so
Mm-hmm.
that's why they have the incentive to join the guild, have their title protected, and as for outsiders, they also under certain pressure, because once like what the guild can do is that they can force the pirate to pay compensation, and they can also force the pirate to destroy the pirate copy, because like people are members are happy to follow their ruling, because they know that if one day their property being infringed, then they can receive similar protection. And then on top of that, there is also this peer pressure thing. So the idea is that if someone violates the rule for the second time, it would be boycotted by the whole trade. So the stake would be high for a repeat pirate. And yes, this is a regional operation, but the fact is that by the time of the first decade of the 20th century, this regional group of booksellers and publishers, they control and corner 80% of the national book publishing industry. So even though this is a regional operation, and it's very, very concentrated just in like a very small geographical area in Shanghai, but that area, so it's as if like if you have self-regulation organization in Wall Street, even though it can only be like a neighborhood, but because that's the heart of global financial service. And so if banks in Wall Street follow a certain rule, then in a way, this is a regime that would have a national impact.
I see. Okay, thank you.
So this is how it works.
All right, thank you. So we are exactly at our ending time. So I want to thank again all the panelists and everyone who participated in the conversation. I hope you guys enjoyed it as much as I did. And please join me in giving like a round of applause to everyone who's been part of this thing across 2 days. And enjoy your weekends.
Thank you, everybody who participated.
Bye.
Thank you. Bye-bye.
Thanks, everyone.
Thank you.
Thanks, bye.
Bye.
Bye-bye.